Welcome to the 7th in a series of political candidate forums in advance of the August 20th primary election. This forum, a cooperative production of the League of Women Voters of Tallahassee, the Tallahassee Democrat, and WFSU Public Media. Today's candidates are running for Leon County Judge, Seat 4. I'm Tom Flanagan of WFSU Public Media. I'm joined by Jim Rosica from the Tallahassee Democrat and Barry Monroe from the League of Women Voters of Tallahassee. We'll be questioning the candidates on various topics, so let's get underway and meet those candidates.
Thank you, Tom. The candidates for Leon County Judge, Seat 4, are sitting left to right. Sidney Brown, Robert Churchill, and LaShawn Riggins. They are all attorneys from here in Tallahassee. The judge's seat is currently held by Judge Augustus Akins Jr., who will be retiring toward the end of this year. For those watching us on social media, please hit the share button and help all of your friends see today's discussion as well. For those at home, here's how the forums are going to work. We'll rotate which candidate gets to answer first. We do have quite a few questions, so we're going to ask the candidates to keep your answers to about 60 seconds. Sometimes shorter if we get into follow-ups. Time will be kept. I understand that we have a bell which will ding when your time is up. Can we hear the bell? Very good. You don't have to come to a dead stop as soon as you hear the bell, but certainly finish the sentence that you're in and we'll move on.
If you're watching on Facebook and you have a question for the candidates, go ahead and type them in the comments and we'll get to as many of them as we can. Time is very limited, so you can improve your chances of getting your questions being asked if you keep it brief and polite. Make a question applicable to all the candidates. Any questions before we start? Then let's jump in with the first question.
All right, let's get right to it if we could. You know, candidates for judicial seats may not be as well known as those for other offices. So could you give us a little bit about your background and experience that qualify you for this judicial position? And I'll give you a minute each to talk about that. And Sidney Brown, if we could start with you, please.
Absolutely. Thank you for the question. My background begins from being in the United States Air Force. I was fortunate enough to be chosen to be a non-commissioned officer in charge of F-15 aircraft at Tyndall Air Force Base. I was a high school English teacher that actually taught here at Ricketts High School and at Second Chance, which is now Gasvini. And I went to FSU Law School. And then I was at the state attorney's office for 3 years. All of those positions, they were positions of leadership and authority. And though I may not have had the title of judge, certainly fairness, equity, equality, the characteristics of a judge that I look for and that I have were displayed even back then.
Thank you very much. Your turn, Robert Churchill, please.
Thank you, Tom. I'm Robert Churchill. I am an attorney. I have been a lawyer here in Tallahassee for almost 22 years. For 18 of those years, I have run a small business as a law office that focuses my time and energy on defending consumers and small businesses in county courts around the state, including the Leon County Court. In that period of time, I've represented thousands of people and small businesses in legal matters, including matters coming before the county courts. And I've had the opportunity in that period to give back. Every week, I devote hours of time to pro bono or free legal work. I've been recognized for doing so by I'm a prior recipient of the Florida Bar President's Pro Bono Legal Service Award. And I have been nominated by the Judicial Nominating Commission for this judicial seat or other judicial seats similar to it in our circuit 4 separate times. I'm delighted to be here with you all, and I hope to earn your vote.
Thank you very much, and let's meet LaShawn Riggins.
Yes, good afternoon. My name is LaShawn Riggins, and I have 17 years of legal experience. I am a Navy veteran. I have had the opportunity to serve as both a criminal attorney and a civil attorney. So I have worked in both areas of law, which I think makes me well equipped for being a county court judge. I've dealt with matters that commonly come before the bench, ranging from criminal matters to civil torts and civil litigation to animal cases to violations of county ordinance. I've worked as a state prosecutor for the First Judicial Circuit, and here in Leon County as the deputy county attorney for a number of years, where I've dealt with matters dealing with government issues. And to me, equality, fairness, equity are very important traits, and all those traits have been exemplified in the work that I've done to date. So I think that I am well suited to be the next Leon County judge. Thank you.
Appreciate that, everyone. Mr. Monroe, you have some questions, I believe, too.
Yes, it is the vision of the Florida justice system to be accessible. That is defined by the Florida courts as being convenient, understandable, timely, and affordable to everyone. What are some of the obstacles to everyone in Florida having equal access to justice? And we'll start with Ms. Brown.
I didn't understand the question. I apologize.
I'll repeat the question. It is the vision of the Florida justice system to be accessible. That is defined by the Florida courts as being convenient, understandable, timely, and affordable to everyone. What are some of the obstacles to everyone in Florida having equal access to justice?
And actually, we started with Ms. Brown to begin, so we're going to mix it up. We're going to start with Mr. Churchill, then Ms. Riggins, and then Ms. Brown. So, Mr. Churchill, why don't you take it first?
Thank you. So the goals for accessibility, as you indicated, have to do with making the process, the court process in any context that you're in, accessible and easy to understand. Where things get tangled up, at least in the county court, many times, is that people do not understand what is happening in a case that involves them directly. And the courts are not as good as they could be at processing through and essentially explaining processes to people. The other great obstacle to equal access to justice, which I think the question tipped on, is money. There are people who have money and resources are better able to retain attorneys of their choosing to handle their legal matters, and some are not. So in the county court, you see many, many people who are self-represented, and that can result in consequences where they are, especially if they're fighting with a lawyer, they don't understand the process that or the rules of evidence, et cetera.
All right, Ms. Riggins.
Yes, I believe the issues stem from both socioeconomic issues. Sometimes there's language barriers, and sometimes it's geographical location. Depending on where someone lives, they may not readily have access to be able to get to court and things of that nature. So some of the problems is infrastructure, also issues dealing with funding for agencies that provide pro bono services and educate citizens of their rights and exactly what services that are available to them to make accessing the justice system a little more simpler. One of the biggest challenges, I do believe, is people not understanding their rights. And if you don't understand your rights or understand the process, a lot of times you don't even know where to begin. And to address that problem, there needs to be greater education of citizens of what services are available, what their rights are, and how to actually access those rights, and then the ability to get to the court system itself.
All right, thank you very much. And now, Ms. Brown.
Thank you. I'm going to have to piggyback off of Ms. Riggins' answer. I likewise feel that there's a socioeconomic divide as between the bench and the people that come before it, especially in county court. And that's why, to me, like when the first question was, what experience do you have? And I've been a practicing attorney since 2003. However, I mentioned a lot of other things that I did prior to that. I'm a mother, I'm a grandmother. And the more experiences we have in life, the more accessible and more understandable we will be, not only of ourselves, but people will be able to understand us. We'll find that we might more often speak the same language and actually understand what a person is being said, and people understand us. It's important that the judge have an affinity with the lives of the people before him and her. That's all. Thank you.
Thank you very much. The next question is going to be asked by me, and that is, how would you describe your judicial philosophy? Is it flavored at all by your politics, and how does it guide your decision-making either way? We're going to start with Ms. Riggins. Go ahead.
Yes. I consider my philosophy to be a judicial moderate. I believe that there has to be a balance, that the scales of justice indeed we need to strive to balance those scales. I believe in upholding the rule of law, but also making sure that we are protecting the rights of individuals and making sure that individual liberties are protected. My career in the military, I've been a public servant my entire career. And so those values from the military and into practicing law have kind of entrenched in me the sense of fairness and equitableness, and making sure that people are treated with respect and fairness, and that you're listening and that people feel that they've been heard. And at the end of the day, while you must apply the law, you can do it in a manner in which it's equitable, respectful, and people feel heard.
All right, thank you very much. Next is Ms. Brown.
Yes, thank you for that question, too. I think it's important in developing a philosophy, is to really put your finger on when it really has started happening and blooming. When I was attending University of West Florida, my children were 14 years old, and my son was arrested. And I attended juvenile court for the first time, court period, I think. I don't even remember before then. And I actually saw my son in handcuffs and shackles, and heard a judge tell me that he couldn't come home with me. I stood on the other side of that bar, and I looked at the prosecutor, and I thought I hated her. But by the time it was all said and done, I bought her flowers and thanked her the last time I saw her. And that's when I was inspired to become a lawyer. As a prosecutor right here in Leon County, I was in juvenile court. And as far as I was concerned, I looked for justice and found it, followed it, implemented it, regardless of to what side of the courtroom I found it. That was important to me.
Thank you very much. And finally, Mr. Churchill.
Thank you. My judicial philosophy, I would not characterize my judicial philosophy as being flavored by my politics. My judicial philosophy is one of judicial restraint. That is, I think judicial power is kind of like the reverse gear in a car or a truck, which is you got to have that gear. The car is not roadworthy without it, and you need to use it as little as possible. When you use the reverse gear too much, you end up backing into things that you didn't intend to, or bumping into things that you didn't know were there. And that's the way judicial power works, in my view. You are required to use restraint. There is plenty of work to do in the county court, plenty of jobs to be done, plenty of nuance and interesting questions to tackle, where you don't have to make policy or delve into the areas of providence of the legislature or the executive. And county court judges aren't often asked to do so, but that's my view of the role of the judiciary.
All right, thank you very much.
Well, on top of philosophy, there's also something called judicial temperament. We hear that an awful lot, particularly nowadays. So we wanted to ask a question about that specifically. How would you describe the qualities of a good judge, and how do you embody those qualities? 1 minute for response. And Ms. Brown, could we start with you, please?
Sure. I was in dependency court for years here in Leon County, and if you've ever been in dependency court, there's more lawyers than there are litigants or parties. but we had developed a kinship. And sometimes we had some very challenging cases, and some lawyers would get upset, some lawyers would cry. You used to get all kinds of things going on. And one thing that I was reputed for, and what they told me about myself that I hadn't noticed, they said, Sydney, you know, the worse it gets, the softer your voice becomes. You just won't let them see you sweat. And to me, it's important to control those elements, because when you're out of control, you can't hear, you don't understand, and all you care about is your point. And as a judge, you have to be able to hear everybody's and be able to weigh things out and not just wait for someone else to finish so you can get back to yours.
Thank you. Mr. Churchill.
My view of the central character qualities of a judge are basically that they need to be temperate, they need to be well-studied and well-reasoned. I have asked around, I've asked judges that I respect this question about their thoughts on this, and the one that I like the best is one that I heard recently. Judges need to listen more than they talk, and they need to be prepared to explain their reasoning to the people who are affected by their rulings. Beyond that, I think a judge should not be delving too far into other concerns that then aren't the central question before the court. As I indicated, the judges have plenty of work to do to decide the cases before them. People are owed answers for the reasoning, and that's about it. I think the central character of quality of the judge is to be temperate, to listen well, and to explain well as necessary.
Appreciate that, and we'll wrap up this line of questioning with Ms. Briggins.
Yes, thank you. I think a judge's temperament, they should be calm, they should be patient, they should be good listeners, they should be empathetic, they should be knowledgeable of the law, they should be able to have analytical skills, critical thinking skills, and be able to put those skills to work at the cases before them. I think that they need to listen and then govern themselves judiciously and apply the law fair and equitably, and always being respectful of the people that are before them. So in essence, you know, you just have to treat people with respect, listen, apply the law, and care about the cases that are before you.
Okay, thank you very much. Mr. Monroe, off to you, sir.
I think we'll start with Mr. Churchill with this question. According to a recent Public Safety Coordinating Council report, 28 people charged with misdemeanor offenses were being held in Leon County Detention Facility for an average of 22 days, with bail amounts of no more than $1,000. Is affordability an appropriate consideration in determining the amount of bail a person must pay to be released from jail while waiting trial?
And just as a notice, this is a two-part question, so we're going to do 30 seconds each. Mr. Churchill, go ahead.
Affordability is, I would say no, affordability is not one appropriate question for determination of a bail amount. Where this becomes a thorny question is where there are programs that are in place, diversion programs, et cetera, that have been designed to allow people to facilitate other methods by which the pretrial release, where they can bond out. And in those situations, the collateral consequences of those is that they have other responsibilities. You have to check in, you have to pay fees down the road. It's more expensive to do that. I don't think affordability is an important factor, but I think it is one factor.
And as a follow-up.
Oh, wait, let's have them all answer that question, and then we can do the follow-up.
All right.
Ms. Riggins,
Ms.
you're
Riggins,
next.
please.
Yes, I'm sorry. Could you repeat the question?
Sure. Is affordability an appropriate consideration in determining the amount of bail a person must pay to be released from jail while awaiting trial?
No, I do not believe affordability is the measuring stick. I believe that the measuring stick should be based on factors such as the crime that has been committed, the risk to not appearing to court, the risk to society if that person is released, and those types of characteristics to make sure that we are protecting society when we are setting bond, but not affordability, no.
Thank you. Ms. Brown?
No, I don't think affordability should be considered, because if you look at it realistically, most people that bond out get the money from someplace else. So the purpose of a bond is if you put your money on the line, then you're more likely to come back to court. No flight risk, no failures to appear. But when mom is putting her house up, getting a second mortgage, and the whole family is borrowing money from everybody, well, when that person bonds out, well, guess what? They hadn't paid a penny. So it shouldn't be a factor.
As a related follow-up, do you see a racial disparity in sentencing in Leon County? Mr. Churchill, we'll start with you.
I do not, well, I don't think there's any question that the statistics show that there are some populations that are more affected by, just by the number of people that are sentenced, that are charged, and there are serious questions to be asked about that. If the question is related to sentencing, no, I don't believe there are sentencing disparities. I think every case is evaluated on its merits.
Thank you. Ms. Riggins?
No, I don't think there is a sentencing disparity. I think that there's a disparity amongst, the crimes that people are getting arrested for. I think there are a lot more crimes that you see with one particular group than others. But in regards to sentencing, no, I do think that the judges do apply the law fairly and equitably.
Thank you. Ms. Brown?
I believe the disparity exists from the time of arrest to the time of sentencing. And I'm not going to say that it's seen in every courtroom by every judge. I've been pretty much in front of most of the judges here in the Second Circuit, and we have some great judges. But however, I have to be able to recognize that there is a disparity. There's a disparity with law enforcement and who gets charged. Some people may get charged with drugs, and others get to go home. And then once they come, there's often a disparity in the discretion that's used and applied.
Thank you, ma'am.
Thank you.
All right, thank you very much. Next question is from me. And it is, what steps, if elected, what steps would you take to ensure your independence from political or any other external pressures? This time we're going to start with Ms. Riggins.
Yes. That's an easy one for me. I mean, there are no external pressures that I face. I've run my campaign grassroots, surrounded by friends and family. I am not beholden to anyone. I believe in law, the rule of law. I believe in justice and equality, and that's what I'm going to do if elected, regardless of what is being put on social media, what's in the news, what people are saying should happen. My job is to listen to the evidence, apply the law, and sentence fairly. And that's exactly what I intend to do.
All right, thank you very much. Ms. Brown, you are next.
Sure. Would you repeat the question, please?
Certainly. What steps would you take, if elected, what steps would you take to ensure your independence from political and any other external pressures?
I agree with Ms. Riggins. That's easy. There will be no pressures. That's my character, whether on the bench or before being on the bench. That's how I live my life. I have a very strong ethical code that I live by. As former military and being in a lot of different positions, rules are very important to me. I'm a rule keeper. And so my integrity is such that certain things I just can't permit to happen and to exist in my life. I have to be able to look at myself in the mirror.
All right, thank you very much. And finally, Mr. Churchill.
I am one of those people who takes absolutely no delight in the fact that these days it seems like almost everything has become political, the culture wars, et cetera. And one of the great privileges of the job of being a judge, as the way that job is regulated here in Florida anyway, is that you do not participate in such conversations. The opportunities now we all have are nearly constant, and a judge or a judicial candidate, for that matter, has an obligation and duty to say, I'm not talking about that, I don't have an opinion on it. That's what I intend to do, is basically to isolate myself from such discussion.
All right, thank you very much. Tom?
All right, we have kind of a connected line of inquiry here, folks, that we can pursue for just a moment here, and everyone gets a minute to respond on this one. Judges, of course, held to high standards as embodied in the state's code of judicial conduct. Could you provide an example of a difficult ethical decision that you had to make in your legal career and how you handled it? Again, that's why you get a minute. Let's start with you, Mr. Churchill.
Well, I am a litigation attorney, and litigation, the way that our system works is an adversarial process where essentially you have two sides fight it out before a decider, whether that is a judge or a jury. And so we're in a contest. Somebody's trying to win. And when you're trying to win, some clients will say, let's do it this way, or why don't we do, and that the suggestion, and often they don't know what they're talking about, but the suggestions that are put to me, or have been in some cases, would take us up to an ethical line. And my job as an attorney is to say, no, we don't do that here. We're going to do everything we can to win this case on the merits the right way. Those are ethical dilemmas that all litigation attorneys face, and that's certainly been true of me in my career, and I haven't bent to them.
Okay, thank you. Ms. Riggins, can you think of a specific personal example?
Well, I kind of have to agree with Mr. Churchill. I am also a litigation attorney, and clients often, in trying to get end results, want those results by any means necessary to get them. And it's also challenging when, you know, that client is your employer. And your employer wants you to do something in order to ensure that they win the case. My job is to give them advice and to give them the best possible advice that I can. I am never going to sacrifice my morals or what I believe is right or wrong. I'm going to always give them the law the way that it is intended, and then the choice is theirs. But I'm always going to choose to do the right thing.
Okay, thank you. Ms. Brown, your turn.
Thank you. And I've been having my own practice since 2007. But in 2003, I started working for the state attorney's office in the juvenile division, and my supervisor wanted me to charge a juvenile a certain way that would have definitely affected him for life and very adversely. I didn't agree with it. It was my case, and he said, well, just, he advised me to just tell people that I told him to do it. I was just doing it because I was out of obedience and submission to him in his position. And I said, I still can't do it. And I just felt that I told him that's not why I'm here, and that can't be my legacy. And he ended up going to then the state attorney, Willie Meggs, and told him the situation. And I kind of felt like a Queen Esther, where if I perish, I perish. I'm going to stand my ground because this is how I feel about it. And when he came back, as it turns out, that Mr. Meggs said I would greet Sydney and give her a case back.
Very good. Mr. Monroe.
Now we will start with candidates. This is 1 minute question. What would you call your greatest accomplishment in your legal career? We'll start with Ms. Brown.
Ooh, let's see, my greatest accomplishment in my legal career. I've had some great accomplishments, but I can't really weigh out one particular one. I'm a trial attorney and a defense attorney, and there's nothing like a client, a defendant that you've been representing who's literally put his life in your hands when that jury comes back and says not guilty. And couple that with the haggling that you do with the state when you know that they're wrongfully charging your client, when they reduce those charges from first-degree felonies to misdemeanors. Those are my greatest accomplishments.
Thank you. We'll go on with Ms. Riggins, please.
Yes, I would say my greatest accomplishment is to be sitting here before you today. I was recently honored by the Tallahassee Women Lawyers Association with the Rose Deep Kitchens Award, which celebrated a woman who had triumphed over adversity and essentially against all odds managed to become a lawyer and to practice law, from studying, at night and sneaking to class and things of that nature, and to be honored with that award and to be in the company of other women who received that award was probably one of the greatest awards that I've received in my life. But the fact that they recognized the struggle and what it took for me to be here, and the adversity and the things that I went through through law school, through my legal career, and the struggles that I had, and yet I'm still in the position where I could be sitting here before you today. I think that is my greatest accomplishment.
Thank you. Mr. Churchill?
My greatest accomplishment in my legal career has been, I think, building a niche business that focuses my practice in county court. When I went out on my own in 2006, I did not have any idea how to run a business. And I have never missed payroll in the 18 years in which I've been running a business. And I have branch offices, or have had branch offices, in St. Petersburg and Pensacola and Jacksonville and Thomasville, Georgia. The best advice I got when I started that business was do what no one else is doing and be good to the people that you interact with every day. That's what I've tried to do, and it has worked out, and it's thrived. And that is, in my view, the greatest accomplishment I have had as a lawyer in my legal career. Certainly the hardest and the best decision I ever made in my legal career.
Thank you.
All right, back to me, I guess. Thank you very much. My question is, how will you approach the task of interpreting the law, and what sources or approaches do you consider most authoritative? For this question, let's start with Ms. Riggins.
Yes. I mean, the law is written by the legislature, and in county court, the laws that you deal from, applying them to the elements of, crimes, to, weighing evidence and the credibility of the evidence and witnesses. And then there's case law out there that also guides your decisions if you have questions as to how the law has been applied in the past in similar circumstances. So although I feel that, the law is pretty easily to be interpreted as written in statute, whenever there's issues as to that interpretation, then you go to, the other courts and the laws that have already been interpreted by other judges, and you apply it in that aspect.
All right, I thank you for that answer. Next is Ms. Brown.
Sure. I think we have a judicial system in America that kind of makes it a shoo-in in interpreting the law. I don't think it's really my job to interpret, because there's so much out there that's already done so, and at county court especially. But the application of the law, to me, is where we really need to focus. It needs to be applied fairly, and sometimes in applying the law, it needs to be applied in a light that's most favorable to a defendant. And then other times, depending on the facts, it flip-flops. It needs to be applied in a light that's most favorable to the state. So it's about being flexible, and it's about being humane. It's the human element that sets us apart from everything else, Because other than that, they can just go by the rule books, get the case law, and look at the four corners of the document, determine a fact, and say, this is how we apply it. But what about that? Once it's ingested, rolled over and mulled over, and then it comes out. It has to come out right.
All right, thank you. And Mr. Churchill.
The question of how laws are to be interpreted by the court system is usually an easy question to answer by reading the law. That is, the typically laws we're talking about are statutes that are codified by the legislature, and the legislature goes through its own process and has committee process, et cetera, and then they vote on the law, and the law as written is the product of that process. It's not the role, in my view, of a judge to look behind how they got to the decision of what the law is. It's simply to read the law as it's written and to apply it as it's written. And usually that's not a difficult task. A county judge is also bound by appellate precedent. So the Florida Supreme Court and in our district, it would be the First District Court of Appeal, which is here in Tallahassee, bind the lower courts, and any trial judge is bound by their interpretation of the law. But other than that, it's just reading it.
Thank you to all.
And but we just heard a mention of the Florida Supreme Court, and as I'm sure you're aware, the motto of the Florida Supreme Court is "Succinto si recte," right? Which is most often translated as "soon enough if correct." So what strategies would you put in practice to manage your courtroom effectively and ensure timely case resolutions? 1 minute for the response. And Sydney Brown, if we could start with you.
You know what I'm going to do to manage my courtroom? I'm going to pay extra close attention when I go to judge school. And let them tell me, because I know how to manage a classroom, and I know how to manage my business, my practice. I knew how to manage those F-15 aircraft that I was in charge of at Tyndall Air Force Base. But this one is a horse of a different color. So I don't doubt my ability to do so. I just will need some instructions on the specifics of managing a courtroom. And I have no reason to think that I'll do anything but exceptionally, since that's my record.
Thank you. Robert Churchill.
What I think I would do for purposes of managing the courtroom and managing the flow of the docket, I think your question had to do with the caseload, really. There's at least on the civil side, there is a backlog of cases that is left over from COVID, and that's because when the courts were shut down for a period of time, criminal cases got first priority, the civil cases backed up. There are tools that are available to judges now to essentially that are underutilized in different courts around the state to move cases through. For example, in small claims court, where I was for 7 different people this morning, a judge has the authority under the small claims rules to say, I can put you, Mrs. Smith, into a payment plan today. It can be $100 a month if you want to do that. The court has discretion to do that, and many times she says, let's do that. And that's the way they do it in Escambia County. They do not do that here. And there are other examples of tools that can be used that way to clear the docket, to move cases through. People feel seen, heard, and understood. It works.
Okay, thank you. LaShawn Riggins.
Yes. To manage a caseload, you have to prioritize. You have to take those cases that have higher outcomes, your criminal cases, and especially those where there may be a person who's incarcerated, and you have to move those cases first. You have to set time schedules in which things have to get done and ensure that the attorneys are adhering to those time schedules. Of course, continuances and things happen, but the judge does have the discretion not to just keep giving continuance after continuance after continuance, and hold attorneys accountable at handling their cases and getting the work done on their cases to move those cases through the docket. So I plan to prioritize and also hold attorneys accountable for getting their cases through the docket.
Thank you.
You'll have a minute each to respond to this question, but it is a fundamental question that kind of goes to your core, I believe. As an attorney, have you ever had to support or defend a legal position that was contrary to your personal beliefs? and how did you do it? We'll start with Mr. Churchill.
I have probably, yes. And it would take me a moment to recall, but essentially when you're making a legal argument on behalf of a client, what you're demanding is that somebody meet their burden of proof. Now, there are some people who are being irresponsible and want my help in being irresponsible. There's a line, an ethical line that attorneys are not allowed to cross. That is when, and what I tell my clients when they hire me is there's 3 ways for me to fire you. One of those ways is for you to ask me to commit a crime. And that line, being invited by a client to break ethical rules, is something that I will not cross. But I don't think that I've ever had a position where I've had to take the position in court that I couldn't stand behind.
Thank you. Ms. Riggins, please.
Yes. I can't say that I have. I've had a pretty wonderful career, and even as a prosecutor, I had the discretion to decide what cases would get prosecuted. And if I did not believe in the case and I did not believe that I could prove the elements of the crime, then, I had the discretion of not prosecuting that case. I've never been forced or put in a position where I've had to choose between my moral compass and what has been asked of me as an attorney. Even working for Leon County, working for a board of elected officials, they don't always agree, but they have never put their politics and their disputes in the county attorney's office. It has always been, here's the issue, how do we get to a resolution? So I've never been put in that position where I've had to choose, nor would I.
Thank you. Ms. Brown.
Absolutely. I have one case comes to mind. As a defense attorney, and I agree with Ms. Riggins, it's much easier as a prosecutor because you have control of the case. Actually, the case is yours. A lot of people think the cases belong to the judges, but they don't. The cases belong to the state. However, in this particular instance, I was a defense attorney. I never asked my clients whether they're innocent or guilty. I don't want to know. It's not about a person is innocent until proven guilty, and it's the state's burden to prove beyond a reasonable doubt. And in this case, we went to trial, and this man cried like a baby when the jury came back and found him not guilty. I think it was because he probably knew that he was, and I suspected that he was, but that I had to put that aside because as an attorney, this is what I signed up for. As a defense attorney, you have to defend as long as you're not put ethically challenged or have to commit a crime in order to do it. Then that was my job, to make the state do their job. And that's what happened.
All right, thank you very much. And that question goes to me. Judges are in some way set apart. You literally sit in the highest seat in the courtroom. But they're also residents of their community. How do you view the role of a judge in terms of engaging with and understanding the needs of the community that they serve? And this time we're going to start with Ms. Riggins.
Yes. Well, I believe that there is a role. Judges are still human. We live, in the community that we serve. I've been a public servant my entire adult life, from joining the military to being a life coach to being a pastor. And so I believe that you can still get involved. You can still participate in your community. You can still work and volunteer to make your community a better place. I don't think that just because you become a judge, you have to isolate yourself. I think you get involved and you show people your human side, and I think that's what builds trust in the judiciary and trust in our justice system, is seeing that human element and seeing judges volunteer and seeing judges take an active role, seeing them in church, and just showing that you are still a human being that cares about what happens in the community in which you live.
That's a beautiful segue into the next question, because social media, of course, has a pervasive role in society right now. And we sometimes wonder, should that also apply to the judiciary? And perhaps more to the point, do you have any social media accounts yourself, and would you keep them and continue to post if elected judge? Ms. Brown.
That's a good question. I do have social media. I have more than I had before because I'm running for judge. But I don't know. I see judges that have maintained social media accounts, and successfully they advertise different events and things that they're doing in the community. So I see it as a plus. I think it's going to have to be more so of as I experience it, what's going to fit and work best for me. As of right now, half the community has my phone number, on speed dial. But however, when you teach people how to treat you, and when roles diverge, you can govern that and help people, make people understand. As a juvenile prosecutor, the public defender, we would do our jobs in that courtroom. And we would go at it, and we'd fight zealously for our positions, her for her clients, and me for the state. But when it was over and the judge announced whatever it was, we went to lunch.
Okay, Mr. Churchill.
To answer your question, I do have I have a LinkedIn account, which is, I think, a work-based social media. I have never used that LinkedIn account until I announced that I was a candidate for this seat. That, I believe, is the only post I've ever had. My campaign has a Facebook account. It's just one of the realities of running for any campaign these days is, I believe, to have a Facebook account. Social media for judges and judicial candidates is regulated as other matters that we talk about. And so social media these days has turned into sort of an online public square of sorts. I'm not terribly involved with social media, but the bottom line is that judges and judicial candidates are not allowed to opine about their opinions about a lot of things in social media or otherwise, and that is the way that I would handle my own business if elected to be a judge.
Okay, thank you. And we'll wind up here with Ms. Riggins.
Yes, I do have a social media account. I didn't use it too frequently until I decided to run for judge, but I think I would probably keep my family account. Being in the military, a lot of my military friends are stationed abroad, and that's how I keep in contact with them and see their children grow up and things of that nature. I do not think that I would have a public social media account, but I do think that I would keep an account to keep in touch with friends and loved ones that are abroad.
Okay. All right. Thank you very much. We in a concern out of time, we've got more questions than we have time to ask. So we're going to move right into an abbreviated lightning round. And what I would ask is you just answer my questions as quickly, as succinctly as possible. And I would ask everybody, who is your closest advisor for this race? And we'll start with Ms. Brown. We'll go down the panel.
Stephen Beasley.
And who is that?
He's a community activist here in Tallahassee. I think it was Bill Proctor or Mayor Daley that said you can't seriously expect to win an election without Steve Beasley on your side.
All right, Mr. Churchill.
Stacy Churchill.
And that would be?
That would be my wife.
All right, very good. Ms. Riggins.
Yes, my pastor and my campaign manager.
And are they the same person?
They are not.
Okay, and who are they?
My pastor is Pastor Kenny Hightower, and my campaign manager is Chauncey Haynes.
Okay, and what church is that?
Heaven to Earth Ministries.
Very good. Do you belong to the Federalist Society, or if not, to any other legal organization? We'll start over here and go this way, Ms. Riggins.
I do not belong to the Federalist Society, but I am a member of a lot of voluntary bar associations.
Mr. Churchill.
I am not a member of the Federalist Society, and I am not other than the Tallahassee Bar. That's the only such organization I'm involved in.
And Ms. Brown.
I'm involved with Tallahassee Women Lawyers, and I think that's the only one I'm actually a member of, but I frequent others.
Does that mean you're also a member of the Florida Association of Women Lawyers? Or is that included?
I don't think so. If it is, I don't know.
Okay, fair enough. Do you think state judges should be appointed for life, or should they have to stand for election as they do now? Ms. Brown, we'll go down this way again.
I don't think any position, any judicial position should be for life.
Mr. Churchill.
I think they should be elected as they are now.
Ms. Riggins.
I think they should be elected.
All right, thank you very much. Outside of your legal career, what would you call your biggest contribution to the community, Ms. Riggins?
That would probably be working through my church, and I'm one of the outreach ministers, and so we're actively involved in dealing with issues with homelessness and women issues, issues facing women and young girls. We stay pretty active in just volunteering and trying to help out whatever we see a need.
All right, Mr. Churchill.
My 25-year marriage to my chief campaign advisor, Stacy Churchill, and our 4 daughters, Allison, Megan, Paige, and Sassy.
Ms. Brown.
I have a nonprofit called Family Resilience Foundation, out of which I help many families in the community. It's primarily a giving organization in that challenges, actual needs are met for people in the community and primarily for children.
All right, thank you very much. We did want to reserve some time now for closing statements from all of the candidates. So you'll have 45 seconds-ish to answer. So we will start, let's just start alphabetically, and we'll start with Ms. Brown with your closing statement.
My philosophy and who I am for now as a judge, will be as a judge, goes way back to playgrounds in New York City, where people would tell me I need to mind my business because I would stand up for the person, the innocent, the meek, and stand between that person and the bully that was bothering them. It started way back then, and it's carried its way all the way through, even as adults. This doesn't have anything to do with you. Why don't you mind your business? I don't like unfairness, and I don't like people being treated wrong. I like justice. In the classroom, I was successful because they understood they can count on fairness and consistency. And I'll be the same way as a judge.
Thank you very much. Mr. Churchill.
I think the voters of Leon County are fortunate to have these 3 candidates in this race, and I'm proud to be in this race with Ms. Brown and Ms. Riggins. I'm proud of the way that we're handling this race and with the civility that we have. And I want this job. So I feel that my experience working in county court as I do, my experience in running a small business, and in representing consumer and business interests is something that complements the existing makeup of the judiciary. And I would be honored to have the vote of the Leon County voters on August 20th.
All right, Mr. Churchill, thank you. And finally, Ms. Riggins.
Yes. My entire adult life, I've been a servant leader. I've always took pride in my ability to connect with people. I've always taken pride in, my ability to advocate for others who aren't able to advocate for themselves. That's just who I am to my core. Being a Leon County judge is kind of the icing on top of what I would call a very blessed career of being able to just serve the community in which I live in, to foster trust, bridge the gap and the disconnect between the citizens and our criminal justice system. I agree with Mr. Churchill. The relationship that we have amongst each other in campaigning has been admirable. We laugh together, we joke. It's been a wonderful process, and I'm very thankful for that. but I also would love to have the vote of the citizens of Leon County so I can continue to conserve this community just in a different capacity.
And that's a wrap. Thank you very much to all of our candidates. Again, Sydney Brown, Robert Churchill, LaShawn Riggins, and to our audiences for joining the League of Women Voters of Tallahassee, WFSU, and the Tallahassee Democrat for this forum.
Well, you can find a replay of the forum also on our YouTube pages, Tallahassee.com and WFSU.org. The recorded broadcast will be Tuesday, July 23rd at 11 a.m. on WFSU 88.9 FM, so please tell your friends.
And remember, you have until July 22nd, that's a week from yesterday, to register or change your party for the primary election. Early voting begins August 10th, with Election Day taking place on August 20th.
And if you have any questions for any of the upcoming forums, please email us at the Tallahassee Democrat at news@tallahassee.com. And you can look for our special election section of the Tallahassee Democrat with interviews with all of the candidates on the ballots, which will be printed and inserted in the Sunday, August 4th edition. Have a great rest of your day. Thanks again.